Welcome to The Laughing Litigator.
Hey everyone, welcome into an all-new episode of The Laughing Litigator with attorney Ray Hsu. I am your host, Mike Leon. Ray here is a California employment lawyer known for mixing sharp legal insight with humor, food stories, and a very honest look at how our system works. Today's episode, we're going to be talking about a question that Ray actually called the California State Bar Ethics Hotline about. And that's a question that mixes restaurants, rules, and a little bit of awkwardness. Ray's going to explain in just a second. Ray, it's good to see you as always. You mentioned that, and I just mentioned in the intro about this call to the California State Bar Ethics Hotline. What made the question feel, as you put it, deliciously complicated? What was the question?
Well, thank you for having me, Mike. Well, I've been kind of a VIP diner lawyer for about 15 years. I eat out a lot. Chinese, Japanese, Korean, Indian, Vietnamese, Italian, French, Mexican, you name it. I even joke that I learned half of my vocabulary by reading menus. Food has always been a big part of my life. So this issue came up when two restaurant workers from one of my favorite Taiwanese restaurants hired me 14 years ago. It was my very first restaurant worker wage and hour case, and I immediately knew it would be an easy win with a sizable recovery for the clients. But the owner knew me well and had even given me a VIP card. So suddenly I had to stop and ask myself, is this a conflict? I remember pacing around my office for almost 2 weeks, seriously debating whether I should just turn the case down. And the same issue happened again after 14 years.
So, Ray, let's talk about the conflict, because you described the situation, right? Lawyer, VIP, customer at a restaurant, you know the chef, you get the usual. So then the employee from that same restaurant is asking for help from a wage and hour case. Is that a conflict as well?
Yes and no, and it depends on the context. So the California State Bar actually has an ethic hotline where practicing attorneys like me can ask questions for free. A lot of lawyers overlook it for all kinds of reasons. But I did call the ethic hotline this time and posed a very similar question recently in 2005 to the one you just said. I felt that I should have consulted this issue with the ethic hotline 14 years ago.
Yeah, that would have been nice, right? So, before we go deeper into more questions, can you kind of describe for the audience in simple terms, how does California define a conflict of interest, especially in situations like you've been describing where a lawyer has a personal connection to a business?
To put it in a simple way, in the conflict of interest rule, for sure, written disclosure, that sort of things, is almost always required if there's a potential conflict or an apparent conflict. So, but at this point, a lot of the listeners, podcast listeners, might think this is something that can be resolved with common sense. The potential recovery from the case versus the value of continuing to go back to the restaurant. And of course, I understood that logic, but it wasn't that simple. I live in the community. I went to the restaurant all the time. The servers and even the owner knew exactly what I was going to order before I said a word, sometimes. That kind of familiarity changes the calculus, and I really want some clarifications.
Ray, some people hear VIP as a VIP customer, and they think it means that you're going to get special treatment, right? In the eyes of the State Bar in California, does being a regular at the restaurant, like you were saying, actually create any legal problem by itself?
The short answer is no.
Can you elaborate on that? Elaborate a little bit more on that.
Usually, as long as the lawyer thinks they can competently represent the case, it's not a conflict of interest issue, but maybe other issues. But it does become a risky business.
When you presented the question to the ethics hotline, what kind of guidance did they give you on the phone there about the personal ties, loyalty, or even the appearance of potential bias?
So after I submitted the question online, the very next day, my phone rang and the caller ID said California State Bar. My first reaction was pure panic. I was like, oh my God, someone finally filed a complaint against me after all these years. And as the phone kept ringing, and then it hit me. Oh, no. They were just calling me back to answer my question. So once I pick up, I'll call the person Mr. Ethic. And Mr. Ethic and I went through the usual disclaimers and pleasantries. This isn't legal advice. It's a hypothetical. It doesn't involve a real client or case, and so on. Then he directed me straight to California Rules of Professional Conduct, Rule 1.7, subsection B, the conflict rule about whether lawyers' representation could be materially limited by personal relationship or the lawyer's own interest. He politely suggested that I should watch out for potential risks to the clients. But my immediate response was, the only significant risk here is me making too much money from the case. That's when he pointed me to Rule 1.7, subsection C, which says that even if there isn't a significant risk, the lawyer still has to make a written disclosure of the relationship to the client. So then I was kind of arguing with him very seriously. So, okay, if I make the written disclosure, can I still go to the restaurant? And then he said, not advisable, Mr. Hsu. It's risky. It could create further conflicts. So I tried again. What about just ordering to go, not dining in, just take out? What about to go? At that point, I honestly feel like I asked a smart and difficult question and that he might not have an answer for it. He did pause for a moment and then redirected me to a completely different rule, which is Rule 4.2, communication with a represented party. It explained that once a business is represented, certain communication with owners, managers, or employees about the subject of the case are prohibited. And that's when my emotions shot up and I blurted out and said, wait, are you saying the restaurant can communicate with me through to-go food while I'm representing the workers? So I really want to ask you, Mark, do you think a restaurant can communicate with you through food?
I don't know, but I know that I love my one restaurant, so there would be a huge conflict of interest. But can I ask you though, Ray?
Yeah.
Let's add another layer to this. If the restaurant already has a lawyer, how do the rules then change about contacting representative parties when an employee reaches out to you first?
Yeah, for management employees, then of course I would tell the person I would need to tell the person to speak to his or her own lawyer first, or the company's own lawyer first. But for non-management employee not seeking legal advice on behalf of the company, then it's fair game. I can talk to them.
What should a lawyer keep in mind when deciding who they speak with and who they should avoid in these wage and hour cases?
Well, they always have to check for conflict of interest. For example, whoever speak to, are they going to affect any previous clients or current clients? So that would be the conflict of interest check for every conversation or consultation.
And what other steps should a lawyer take to make sure that the worker understands the situation clearly, especially like in the situation that involved you, that you've been a longtime customer at the restaurant? I mean, they know your order before you even place it.
Oh yeah, sometimes the workers will even came to me and say, "Oh, I saw you all the time," and I short of saying I was the one who prepared your food. Yeah, but so I just have to be careful. I have to make sure whether or not I spoke to the management before, or I spoke to the owner of the company before. And then after the conflict check, then I will determine whether or not I can speak to the workers.
Ray, as we wrap on this episode, the big question that I have behind all of this is in the real world, does this kind of create a true conflict of interest, right? Or does it just make for an awkward dinner reservation the next time you head to that restaurant?
Well, I will phrase it this way. It's an ambivalent problem for every foodie lawyer like me. I actually had my first taste of this long before I became a defense attorney. When I was volunteering at legal aid before law school, a supervising attorney once announced that we couldn't eat at certain restaurants or shop at certain retail stores because the legal aid started to represent the workers. That was the moment I knew my path would eventually lead me to become defense lawyer, the evil one as the nonprofit lawyer joke about all the time.
Ray, thank you so much for the time, the storytelling, the insights. I appreciate it as always.
Thank you.
And that wraps up today's episode of The Laughing Litigator. If you want to learn more about Ray's employment law work, do me a favor, visit rayhsulaw.com. Thank you to everyone for listening to this episode, but don't forget to like, subscribe, leave a review, and comment or share it with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.